You described handler DNA recovery. Is that correct?
Yes.
At least in some part?
Yes.
And in recovering handler DNA, it's very frequent that what you recover is a partial profile. Is that correct?
That's correct.
And that's because of, essentially, it produces a low-level reflection of a DNA profile. Is that true?
Yes.
And the statistics that result from that are essentially not the type of statistics that you've reported in the quadrillions, but frequently in the hundreds. Is that correct? 1 in 100 random match possibility.
That is possible, yes.
And that is entirely consistent with handler DNA. Is that true?
It can be at times, yes.
Okay. Meaning there are some times if somebody has handled something for a long period of time, they deposit more DNA on it, correct?
Yes.
If they've handled something and it has been some time since, DNA can degrade,
Yes.
correct? There are plenty of things that can be interposed between the handling and the ultimate testing that can cause that to degrade, even if it started off as a large quantity of DNA. Is that correct?
Yes.
And so the circumstance of testing something to determine whether or not it has DNA on it, if it had been previously handled, there's really only one way to do that. Is that correct?
I'm sorry, I'm not sure I
There's only
understood your
really
question.
one way to determine whether or not there is handler DNA on an item. Is that true?
Yes. That would be to swab the item.
That's the only way to do it. Is that correct?
Yes.
Now, in this particular case, you indicated that you found 3 extraneous alleles.
Correct.
And is that consistent with somebody using a non-sterile pen to have handled the item previous to your it being swabbed and sent to you?
If there had been DNA on that pen, that would be one of the possibilities, yes.
Thank you. Nothing further, Your Honor.
Nothing further, Your Honor. Thank you.
Oh, thank you.
Your Honor, come to the sidebar. Thank you. Your Honor, at this time, the defendant would offer a stipulation of the parties. May I have it marked, please? May I ask for it to be marked as an exhibit?
May.
Your Honor, it's very short. May I read it to the jury? Stipulation of the parties regarding toxicology of the blood of Odin Lloyd, Exhibit 439. The parties stipulate that the blood taken from the body of Odin Lloyd at the time of his autopsy tested positive for the presence of marijuana. Signed by defense counsel, by the prosecutor, and by Mr. Hernandez. Your Honor, at this time, members of the jury, the defendant, Aaron Hernandez, rests.
Thank you. Any rebuttal witness?
Your Honor, the Commonwealth calls Dr. Martin Brecker, please.
If you could please face the clerk and raise your right hand.
Sir, do you solemnly swear that the testimony you're about to give to this court and this jury will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir.
Good afternoon, sir. Could you please state your full name and spell your name for us?
Martin Brecker, B-R-E-C-H-E-R.
And how old are you, sir?
65.
And are you engaged in a profession?
I'm a psychiatrist.
And could you just tell us what your training and experience is as a psychiatrist, please? Go ahead.
I trained at Downstate Medical Center where I received my medical degree. I did residency at Downstate Medical Center. I received a research degree in psychiatry from Downstate Medical Center, practiced in Brooklyn for 10 years, after which I went to the FDA and was a medical officer at FDA for 2 years. I worked in the pharma industry for 22 years and then went back into practice in 2013.
And prior to attending medical school, where did you go to college?
MIT,
And what's your undergraduate degree in, please?
Humanities and Science.
And could you tell us, when you went to medical school, you obviously have a degree as a medical doctor, is that correct?
Correct.
But your field of practice has been psychiatry?
Correct.
And in addition to being a medical doctor, did you receive any additional training?
I have an MBA from Wharton, and as I said, a research degree in psychiatry from Downstate Medical Center.
And in the course of your career, did you come to write an article on phencyclidine and violence, clinical and legal issues that was published in the Journal of Clinical Psychopharmacology in 1988?
Yes.
And could you tell us, please, in the course of the research for that article, did you come to a conclusion about PCP, phencyclidine, and violence?
Yes, I did.
And did you state that in your article?
Yes, I did.
And that article was subject to peer review, is that correct?
Yes.
And it was then published, is that correct?
Yes.
And could you tell the jurors, please, what was your conclusion about PCP and violence as you stated it in your article, please?
There was a belief or an assumption in the field at that time that phencyclidine, in ways that was not understood, promoted or induced violence in individuals. And our review of the literature showed that that assumption was false, that there were very few cases of documented violence where an individual could be shown to have ingested PCP and nothing else, which were associated with acts of violence. In fact, we could only find 3 such cases in all of the medical literature that we reviewed in 1987. And that was during the period of time during which phencyclidine was a commonly cited drug of abuse. And as I said, there were only 3 such cases that met our 3 criteria of having a observed act of violence, documented PCP in the body fluids of the perpetrator, and the absence of other substances or other drugs, legal or otherwise, that might have predisposed to violence.
And that review dated all the way back into the 50s and the 60s when PCP or phencyclidine was used as an anesthesia, is that correct?
That's correct, and that brings up an important point.
You've answered the question.
And as a result of your research, did you state that conclusion that any such belief was therefore associating PCP with violence was not warranted?
Yes, I did.
Thank you.
Thank you. We're going to take a recess at this time. Please don't discuss the matter among yourselves and then meet.
All right, jury, please.
So rebutting what Dr. Greenblatt testified was his understanding of the contents of the article, I believe that the jury should be so instructed that the testimony of this witness was offered for the limited purpose of rebutting what Dr. Greenblatt may have testified was his understanding of the contents of an article about which he was questioned. This witness's testimony is not offered for the truth of what may have been written in the article, only that it was written.
That would be fine.
We'd object to that, Your Honor. The witness was on the stand just about...
Right, and that was the purpose, and that was
I
what
understand
he
that,
did.
Your Honor. However, they bring a witness in who's asked about PCP. This is Dr. Greenblatt. He then tries to say, no, this other guy, this is what he meant. So that witness is now on the stand. He testifies to what he meant. That is offered to rebut and to explain what he actually meant.
It's not going to come in for the purpose that In fact, there is no correlation between PCP and violence, because that was totally predictable that that's what Greenblatt was going to testify to. His affidavit said that the psychosis PCP includes aggressive and violent behavior, that it includes unpredictable aggressive behavior, the behavior is unpredictable, that individuals behave normally 1 minute and violently assault of another, and furiously and unexpectedly attack without provocation. Given the fact that that was completely predictable, and therefore if the Commonwealth had intended to use this witness to rebut this, when the Commonwealth was asked if they were going to rebut this with a witness and didn't disclose until 1:30, was why I've limited it to this purpose. And I think since it's been limited to this purpose, since the only reason the court allowed this witness to testify was because the Commonwealth indicated it was surprised by Dr. Greenblatt's statement as to the conclusion having been taken out of context, I allowed this witness to testify. But that does not all of a sudden mean that the conclusion is then in for the truth of what's in that conclusion.
What you remember, Your Honor, he was the editor, Greenblatt was the editor. This was printed in his thing. He was asked about it. He said, yeah, I remember that. And he said, what you're trying to suggest is not accurate. In fact, it's exactly accurate. And again, being offered to rebut what he said and what actually his opinion was at the time. I don't see how that gets carved into two pieces. Oh, no, you get to say that it rebuts it, that he can't testify about what somebody else actually meant, but then the underlying substantive part about what he meant now is then instructed, well, don't pay any attention to what he meant. I think those two things necessarily go together.
Thank you. We can bring the jury back.
I just want to object to being required to cross-examine this witness after
If you want more time to read the article, it's this very limited purpose as to whether the statement is or isn't, whether the conclusion is or isn't an accurate summation of the article. If you need more time, I will give you that more time. That's the only purpose that he was allowed to testify. The court is reiterating, is telling the jury that that's the limited purpose, and if you need any more time as to whether that conclusion is a fair summary of the article, you may have it.
I don't need more time to read the article, Your Honor. I do need more time to look into Dr. Brecker. In the little time I've had, I understand that there's some controversy about off-label marketing when he was a pharmaceutical company executive.
If you want to take more time, you may have it. I'll keep the jurors out.
Have them
you want any more time today?
Another 20 minutes is not going to do any good. I'll go ahead.
Okay.
My point is that I would like to be able to investigate this man overnight.
I will give you...
in order to cross-examine him properly.
The jury can come down.
17, line them up and bring them down, please. We want the witness on the stand.
Right this way, please.
before we start with any cross-examination, let me instruct you that the testimony of this witness was offered for a limited purpose, for the limited purpose of rebutting what Dr. Greenblatt may have testified was his understanding of the contents of an article about which he was questioned. This witness's testimony is not being offered for the truth of whatever words may have been written in that article, only that certain words were in fact contained in the article. You may examine the witness.
Good afternoon, Dr. Brecker.
Good afternoon.
So, you published this article in 1988,
Yes.
and you had 3 criteria by which you made determinations, is that right?
We judge the cases in the literature.
Try my question. Okay, you had 3 criteria, is that right?
We had 3 criteria by which we judged cases in the literature.
Can you answer my question, yes or no? Did you have 3 criteria?
Yes.
Okay. The first criteria, did the subject commit or attempt to commit an act of violence against another person? And if so, was the act or the attempt corroborated by other observers, i.e. medical personnel, police, or witnesses?
Yes.
That's criteria number 1, correct?
Yes.
So that if it was a self-inflicted wound, that would not count in your criteria, is that right?
Correct.
Now, the second criteria was PCP documented in the subject's urine, blood, or other body tissue, correct?
Correct.
And so if someone reported that they had ingested PCP, that didn't count.
Correct.
And if someone witnessed the person smoking something with a distinctive odor, unless it was examined in the laboratory, that didn't count.
Correct.
And the third criteria was the presence of other drugs, particularly alcohol, ruled out by examining urine, blood, or other body tissues, correct?
Correct.
So if I've smoked PCP and I've had a beer, I'm going to be excluded. Can you answer that? Alcohol and PCP, that doesn't come into your criteria, right?
But it was by examining the urine, blood, or
Yes.
other body tissue.
So if I have alcohol in my urine,
Correct.
or blood, or body tissue, I'm going to be out.
That's right. That case would not be counted.
All right. So, do you agree with me that psychosis associated with PCP intoxication is well recognized?
Yes.
And that was true in 1988.
Yes.
And would you agree with me that it's characterized by cognitive disorganization
Among other things.
and disorientation
Could be.
and hallucinations
Sometimes.
and paranoia?
Sometimes.
And in fact, you've written about that in your article, is that right?
Yes.
You wrote, psychosis associated with PCP intoxication is well recognized. It is characterized by cognitive disorganization, disorientation, hallucinations, and paranoia, i.e. all the features of an acute brain syndrome.
Yes.
Correct?
Correct.
I read that correctly?
Yes.
Now, is it also the case that PCP intoxicated patient may not be restrained by pain?
To some extent.
Well, did you write in your article, furthermore, a PCP intoxicated patient may not be restrained by pain?
Yes.
And would you agree with me that this may account for reports of individuals high on PCP who seem to have extraordinary strength,
Yes.
and of individuals who inflict gruesome injuries on themselves?
Yes.
And that person would be excluded from your survey because they inflicted an injury, a gruesome injury, on themselves.
Yes.
Would you agree with me that a third factor in PCP intoxication, to which relatively little notice has been given, is the hyperactivity it induces.
I wrote that.
And you agree with that?
Still do.
And you agreed with it in 1988?
I wrote it.
Well, I take it you agreed with it.
Yes.
All right. Now, did you report that we are well aware that the failure of most case reports to meet our criteria does not prove that PCP does not induce violence?
I wrote that.
And in fact, you recognized in the article and in what I just read that most case reports don't meet your criteria for one reason or another.
That's right.
Because they didn't have a lab test establishing PCP, correct? That's one of the reasons?
Correct.
Or there were polysubstances in the urine or tissue, other substances besides PCP,
That's right.
or it was only self-inflicted wound.
No. The criteria was it was an act.
One of the criteria was that it had to be inflicted on someone else.
Correct.
Correct?
Correct.
So a self-inflicted wound wouldn't count,
Correct.
right? And am I correct in understanding that our data led us to these conclusions? The combination of cognitive disorganization, paranoia, analgesia, and activation contributes to a toxic state that is difficult to manage clinically and which carries with it a potential for injury.
Yes.
If you could just make it clear that you were reading from the article.
Yes, Your Honor. Was that a quote from your article?
Yes.
Dr. Brecker?
Yes.
All right. And did you also go on to say in your article, PCP psychosis, however, should be distinguished from criminal behavior, which is usually goal, parentheses, money or lust, oriented, and often committed by individuals with histories of violence and criminality.
I wrote that.
And you agreed with that, is that
Yes.
correct?
Yes.
And you also agree, would you not, death resulting from the behavioral toxicity of PCP should be distinguished from violence directed against others, correct?
Correct.
And then you concluded your article by stating, the toxic state induced by chronic or excessive PCP intake establishes this substance as a highly dangerous drug of abuse without medical use and thus warrants its Schedule I status, but does not support the belief that PCP induces violence in individuals not so predisposed.
I wrote that.
And that was your conclusion. That was
Yes.
your concluding sentence.
Correct.
Nothing further, Your Honor.
There were a number of things that Mr. Rankin left out of your article as he was reading these sentences to you, is that correct?
He read portions of the article, not all of it, of course.
Right. He left out that PCP users were not frequently represented among those arrested for murder, assault, or rape. True?
Well, I object to this, Your Honor.
He left that sentence out, correct?
Correct.
He left out the sentence that says, PCP-induced psychosis lasts from hours to weeks. Is that correct?
Correct.
And that was a finding that you made on specifically not intoxication, but PCP psychosis. Is that correct?
Correct.
Objection, Your Honor.
That state lasts not for seconds or minutes, but hours into days. Is that correct?
Talking about what was in the article.
Yes.
Yes.
And that state, psychosis, that's the state where there's positive and negative symptoms of psychosis that are associated with PCP. Is that true?
I object to that.
Objection is sustained.
Well, you described symptoms, positive symptoms related to psychosis. Is that correct?
Objection, Your Honor.
Objection sustained.
Do you describe psychosis, PCP-induced psychosis symptoms in that same paragraph?
I described PCP psychosis in the article, yes.
Right. And that's what you're talking about, those symptoms lasting for hours to days. Is that correct?
Yes.
And those positive symptoms, the positive symptoms of PCP psychosis, those are readily observable, are they not?
Objection, Your Honor.
Objection sustained, answers, question sorted, stricken.
What are those?
Objection.
Objection sustained,
Are they described here in this sentence? The positive symptoms of PCP psychosis on page 400 in the right-hand column, first full paragraph, second sentence.
There's a list of symptoms associated with PCP psychosis.
And
I
those
believe
things,
that was read to the doctor on cross, Mr. Bumber.
those things are observable, are they not?
Objection, Your Honor.
objection sustained,
Disorganization, disorientation, right?
Yes?
Impairments,
Are you going to read the whole sentence, Mr. Bumber, please?
i.e. all the features of an acute brain syndrome, correct?
Yeah, I would request that he be directed to read the entire second sentence as I did.
It is characterized, well, you then left out the next sentence.
you may
It
read.
is characterized by cognitive disorganization, disorientation, hallucinations, and paranoia, i.e. all the features of an acute brain syndrome, correct?
Correct.
And is that where you're describing positive symptoms of PCP psychosis?
Yes.
And those PCP-induced psychosis last from hours to weeks. Is that not true?
That's true.
And down in your last paragraph, our data led us to these conclusions, the combination of cognitive disorganization, paranoia, analgesia, and activation contributes to a toxic state that is difficult to manage clinically and which carries with it a potential for injury, correct?
Correct.
And then you caution against, though, that's different from criminal behavior, true?
True.
And you ultimately conclude the toxic state induced by chronic or excessive PCP intake established this substance as a highly dangerous drug of abuse without medical use and thus warrants its Schedule I status, but does not support the belief that PCP induces violence in individuals not so predisposed, correct?
Correct.
And that's your finding?
Correct.
And that's when you indicate that in your article, one of the legacies of PCP abuse is the assumption that it provokes violent behavior in humans with predictable regularity. And then you say, these findings, plus the pre-1970 prospective evaluation of thousands of patients with PCP, in which violence was never reported, led us to conclude that clinical and forensic assumptions about PCP and violence are not warranted. Is that your conclusion?
Yes.
So, you would agree with me that there are times when a PCP psychosis can last for weeks?
Yes.
You wrote that?
Yes.
And the test for blood or urine, how long does blood or urine catch PCP in the bloodstream?
I'd object, Your Honor.
Is there a period of 12 to 24 hours that blood or urine can pick up PCP?
Objection sustained.
Is that something that's in your article?
I did not discuss the laboratory tests for PCP in urine or blood.
Okay. But if it didn't detect it by laboratory test, you didn't count it.
I object.
Rule, that's
Correct?
in previous testimony. I'm going to ask you not to go back over
Yes, Your Honor.
what you did.
That's all.
Thank you.
Wait for a second, please.
other rebuttal witness?
No further rebuttal witness, Your Honor, the Commonwealth rests.
Sir, rebuttal witnesses.
No, sir, rebuttal, Your Honor.
Thank you. At this time, you've now heard and seen all the evidence that you're going to hear and see in this case. Two very important parts of the trial remain. The attorneys have a chance to make closing arguments to you about the evidence that has been presented, and I will be giving you detailed instructions on the law. So, even though you've now heard all the evidence, I'm going to ask you to continue, please, to keep an open mind. It's very important that you not stop making up your mind until you know what the law is, until you know that you not start trying to, in your own mind, decide whether the Commonwealth has met its burden of proof before I tell you exactly what it is that the Commonwealth has to prove. So please continue to keep your mind suspended, continue to avoid anything at all about the case or Mr. Hernandez that could appear in any of media, newspaper, radio, television, magazine, or in any social media, Facebook or Twitter. Please continue to avoid speaking to anyone at all, including each other, family, friends, anyone not communicating in any way about this case, including through emails or texts or any other form of communication. No communication about Mr. Hernandez or about this case, about your jury service, and if anyone communicates with you in any form, end it immediately. Please do not do any research at all about this case or Mr. Hernandez or anything you think could in any way be relevant to the case. We will see you tomorrow morning. As I indicated, we will have closing arguments and the court's instructions around the law, and then the case will be yours to deliberate about. Thank you.
He. All persons having anything to do before the Honorable, the Justice E. Susan Gosh of the Superior Court, now sitting at Fall River within and for the Commonwealth, depart and give your attendance here tomorrow morning at 9 a.m., to which time and place the sitting of this court is now adjourned. God save the Commonwealth of Massachusetts. Court is now adjourned.
Matters that were left over from last week. One was the request for an instruction on no obligation to volunteer anything to the police. Commonwealth cited 26840 in opposition to such an instruction. I've received the defendant's memorandum. Anything either of you wish to argue on that before I rule?
Your Honor, we submitted a memorandum this morning.
Right, as I said, I've received that.
I
Anything
don't need
else?
to add to that, Your Honor.
Thank you, Ms. McCauley.
No, Your Honor, I'd just say that we've not asked the court to affirmatively instruct on it, but at the same time, they've asked just the opposite, and I think that's a misstatement of the law, so we stand with our prior...
The misstatement of law because of the statute.
Correct, Your Honor.
Chapter 268, Section 40 requires a person who knows that another is a victim of certain crimes, including murder, and is at the scene of the crime to report it to law enforcement to the extent they can do so without danger or peril to himself or others. There does not appear to be any case law applying this statute, but the Supreme Judicial Court in Commonwealth versus Lopes, a 1945 case, found insufficient evidence of the possible common law crime of misprision of a felony, where the defendant's failure to disclose information was motivated by fear of self-incrimination. As the defendant points out in its memorandum of law, many states and several federal courts have interpreted analogous statutes to preclude enforcement where reporting a crime could lead to incriminating the reporter. The Fifth Amendment privilege prohibits, in effect, the Commonwealth from requiring its citizens to report their own wrongdoing to authorities. In this case, given the state of the evidence, application of this statute to Mr. Hernandez would be precluded, given that any disclosure of him could have tended to incriminate him either in the underlying felony or in the crime of accessory after the fact. The substance of the requested instruction is supported generally by the case law. In Commonwealth v. Senior, a 2009 case, the SJC found that the trial judge had properly instructed the jury that there is no legal obligation to report a crime to the police. And in Commonwealth v. Nickerson, a 1982 case, in which the SJC stated the defendant had no duty, as the Commonwealth conceded in that case, to report the crime, citing the Lopes case, nor any duty to offer exculpatory information, and that the judge had rightly advised the jury accordingly. The Supreme Judicial Court did go on in that case to find error in allowing the jury to doubt the defendant's veracity if the jury found the defendant had not come forward to disclose that he was at the scene of the crime, that he saw the victim attacked, that he saw a weapon at the scene, that he knew who the attacker was, noting that such disclosure might also have shown that the defendant left the scene in a vehicle with the attacker, which would have gone a long way to proving that the defendant committed the crime charged. Given the testimony about the contacts between the Commonwealth and between the police and the defendant, I think there is a real risk the jury might draw an adverse inference, even if the defendant doesn't, even if the Commonwealth doesn't argue that as conscious of guilt positively. The court, therefore, will instruct that the defendant was not obligated to report a crime about which he may have had information or to volunteer information about a crime to the police, and that the jury cannot draw an adverse inference from the defendant's failure to volunteer any information he might have known about Odin Lloyd's death to the police. The defense has not requested a similar request with respect to the evidence that was elicited, that as Mr. Hernandez was walking back into the house and the police were sort of walking behind him, he said something to them to the effect, "You're not coming into the house," and they perhaps don't want the jury reminded of that remark, but I thought it made sense to raise it just to ensure the Commonwealth was not going to argue that that statement by the defendant is somehow reflective of consciousness of guilt, since there's obviously a Fourth Amendment right not to allow anyone in the house without a search warrant. So I just, you're not planning to argue that as conscious of guilt, are you? Or are you?
I actually had quite, I guess you're catching me off guard with that suggestion that he volunteers a statement to the police at that time. They didn't do anything to suggest they were coming in. He makes a statement that they're not coming in, which would evidence a consciousness of guilt. He, of course, he doesn't have to Loy's like family. Contradicting
we're not
that
talking
evidence.
about that statement. This
Well, again,
is a
Your
very
Honor.
specific one. There's statements he made about Owen LaFairley or when he last saw Odin Lloyd. This is a very specific statement that I'm asking about, not about all his other statements to the police at the scene with respect to when he last saw Odin Lloyd.
Well, and again, it's a volunteered statement by the defendant. They've done nothing to suggest they are trying to come in. That would evidence his state of mind and a consciousness of guilt, particularly where he then immediately, following that, as the evidence is shown, engages Shayanna Jenkins to start removing things from the home. So that would be indicative of his knowledge that there are things in the house. He volunteered it. Wasn't in response to any question. They didn't suggest they had a search warrant. They weren't trying to get into the house at that time. He made that statement. So I would suggest that would be admissible.
Your Honor, I think there's no difference between an individual saying, I'm not going to talk to you, meaning the police, and you're not coming in the house. I mean, they're both an expression of an assertion of a constitutional right, and it can't be used against the defendant, period.
The court rules that that statement cannot be used as conscious of guilt in your closing. There was issue raised, or possible issue raised by the defense as to whether it was proper to charge joint venture firearms. Is that
Your Honor, I've looked at that. Your Honor's analysis was correct. We will withdraw that request.
It also turns out that there is a 2013 firearms case.
I'm sorry, I was unaware of that, Your Honor. I would not have made the request, and I
Commonwealth
apologize.
versus Humphreys.
We withdraw.
Thank you.
If I could just clarify something from the other day, because I might have I think maybe you and I were speaking about two different things. It was about the denial made to Shiana Jenkins. There were two separate statements. I think I was thinking of one, and maybe the court was...
I was thinking simply of the statement where she said, did you do it, or something to that effect, and he said, I'm innocent.
Right, because there was another statement where she said, do you know anything about it? He said, I don't know nothing. So, and that is what I guess
Right,
I was
I'm talking about the denial.
Okay, thank you.
Unequivocal denial is the language.
I'm sorry, Your Honor, I'm filing one more.
Sure, I think I may have in...
There was one filed this morning.
Right, that's me. The one that you filed this morning, I think I may have in my lobby, but I do think I remember it, which is that I do instruct the jury that the fact that the case is brought in the name of the Commonwealth entitles the prosecutor, in effect, to no greater or lesser consideration than any other litigant. And then I go on and say something like, all parties, whether prosecution or defendant, stand as equals at the bar of justice. So that's, I think, the sum and substance of the first sentence you've asked for.
That's covered.
I'm not going to do the second sentence.
And Your Honor, I just gave Mr. McCauley the third supplemental, so to be fair, I think, I don't know if the court should really take it up now. They should have a fair opportunity to respond to it. That's for what it's worth.
You're seeking to draw an inference against the failure to call the case officer? Is that what this one is?
It's missing witness instruction, as set forth.
Did you want to respond to that today, or did you want some time?
Your Honor, I'll respond.
If you want to do
so we
it,
can
if you want to do it
focus.
tomorrow morning, you can do that too.
Okay, we can do that. Thank you.
If you could just look at the verdict slips. I'm asking you to look at them for form. Clearly, the defense has argued that the court should not include extreme atrocity or cruelty.
The verdict slips.
Defendant's contempt, Your Honor.
Thank you. See you tomorrow morning.
Court all rise.
You can